Hey, what's good, what's good, what's good, what's good? Welcome to D Smith Let's Discuss. Welcome to today's session. Today's session, can you believe this? Can you believe this? Keffe D, who is accused of unaliving Tupac, has repeatedly sought dismissal of his murder case in Las Vegas, arguing constitutional violations due to the delayed prosecution of prior immunity deals from his public confessions. With his legal team taking their request to the Nevada Supreme Court after a district judge initially denied dismissal in early 2025. Though he remains charged, as of today, his attorneys claim he made incriminating statements under an alleged immunity agreement with law enforcement in exchange for his cooperation, as reported by ABC News. If you remember, he went all over. He stayed on Vlad TV. He even wrote a book detailing what happened to Tupac. Check this out, man.
That he has immunity from everything. He decides to write a book. And in his book, he talks about his career as head of the Crips gang, but he also talks about his role in Tupac's murder. That, not his proffer agreement, but his own story, his own book, got him indicted.
Over 29 years after the high-profile murder of rap icon Tupac Shakur, Duane Keffe D Davis stands accused of orchestrating the hit. Davis confessed to his alleged involvement in 2009, but it was under a so-called proffer agreement which protects suspects from criminal prosecution. However, investigators say Davis stepped outside that agreement by confessing to the crime in interviews and in his memoirs called Compton Street Legend. Good evening. Thank you for joining us. I'm Steve Wolford. Now, attorneys for Davis are contesting evidence collected by police during what they call an unlawful search of his home 2 years ago. News 3's George Acosta has been going through the newly filed court documents and joins us now in studio with more. George.
Well, yes, Steve, within this nearly 30-page long court filing, Duane Keffe D Davis and his attorneys are challenging the validity of a July 2023 search warrant of Davis's home, citing several reasons as to why they believe evidence obtained from that search should be suppressed and not used in the trial connecting Davis to the 1996 killing of Tupac Shakur.
That search warrant contained a nighttime clause, which is curious. You've got a case that's nearly 30 years old, yet you have this 24-hour nighttime search, this 24-hour authorization.
Davis's attorneys who spoke with media outlets back in August say the motion to dismiss evidence was just one of several filings they planned to execute at the time.
Anytime you have a cold case, obviously there's concerns. There's degradation of evidence, loss of witness testimony. We anticipate challenging this case on those grounds as well.
Now, within the newly filed motion submitted Monday, Davis's legal counsel highlights what they claim to be insufficient reasonings as to why a nighttime search warrant of Davis's home was needed and evidently executed after nearly 3 decades had passed since the September 1996 killing of Shakur. And while Davis's attorneys seek to suppress the evidence found,
everything. We understand that there was rounds of ammunition found, which is our position, have nothing to do with this case whatsoever. There was a great deal of documents that were taken.
They further argued the search warrant was based on flawed claims, using statements previously issued by Davis as evidence, citing what his attorneys claimed to be contradicting evidence of Davis's statements claiming he had been in the front passenger seat of the vehicle from which Shakur had been shot.
These statements that he made will be addressed. The context in which those statements were made will be addressed.
In the meantime, Davis's attorneys are asking for a judge to either suppress the evidence or for that judge to hold an evidentiary hearing challenging the affidavit.
At the end of the day, it's results, and we're seeking obviously results that are beneficial to our client. We anticipate giving him the very best defense available and that we can provide.
Now, a hearing for that motion to suppress the evidence is scheduled for January 6th. Now, that is all followed by a jury trial, which is scheduled to begin in August. But for now, reporting in studio, George Acosta, News 3.
All right, thank you, George.
So, what do you think? That boy out of there. That boy out of there. Definitely going to jail for life. Let me know what you think. Like, comment, subscribe. Welcome to the session. I'm out of here.